We are going to read this case from the Ninth Circuit. This is the Koala, a student newspaper, versus the University of California. So this is a public university. And as we're going to read, what happened is the Koala published a news article or published an article saying that basically mocking the concept of safe spaces. And then the student government defunded all student media 2 days later. And the newspaper complained that this was First Amendment discrimination, which is a relevant issue because the University of Colorado, the University of California is a public university, and therefore there are First Amendment implications that apply even to student government because they're part of the university, and therefore state action is implicated. So we're going to read this and see what it has to teach us because I think it's an interesting issue.
Just 1 second. People in chat are saying that Leonard is low. I don't know if it's possible to turn him up
Hold
on
on.
your end.
And let's see, how do I do that? Leonard, go here. I can.
This could all be things on my end. I'm restarting from default here, so
I have now doubled your
No, no,
volume.
no. Your voice is fine on my end. I think he just needs to turn him up on his Discord.
okay.
I've doubled your volume,
You
so
right
hopefully
click
it'll
on
help.
Leonard.
I
Oh,
figured
yeah,
it. All right. So let's read the summary. Fortunately, they provided a summary, so it will get us through the major point faster. The panel, referring to the Court of Appeals because they sit in three-people panels, the panel reversed in part and vacated in part the district court's dismissal of a complaint in an action brought by the Koala, a registered student organization at the University of California, San Diego, alleging the student government's passage of the Media Act, which eliminated registered student organization funding for all print media, violated the Koala's First Amendment rights. The district court dismissed the complaint for failure to state a claim, and the Court of Appeals is reversing that decision in part, saying that they do have some kind of claim. Let's read on. The Koala alleged that student government passed the Media Act 2 days after the Koala published an article in its newspaper satirizing the concept of safe spaces and trigger warnings on college campuses. The article generated numerous complaints from students and administrators and prompted the university to publicly denounce the article's offensive language. I love the article already. We may have to see if we can find it. In reversing the district court's dismissal, the panel held that the 11th Amendment did not bar the Koala's claim for prospective injunctive relief. All right, so a little bit about the 11th Amendment. It's a very interesting clause of the Constitution, and it's a bit of a pain. But basically what it says is, on its text, is that no citizen who's a citizen of another state can sue a different state in federal court. This came about very early in the U.S.'s history, as the number 11 would suggest. But the problem is there's another clause in the Constitution which says that a citizen cannot sue their own state in federal court. So you can't sue your own state under the Constitution, and you can't sue another state under the 11th Amendment. Now, a lot of that has been modified by the 14th Amendment, because the 14th Amendment gave Congress the power to pass laws to provide, for example, equal protection. And so Congress has modified essentially the 11th Amendment by the 14th Amendment because the 14th Amendment gave a different source of power. But that's what they're talking about when they say the 11th Amendment. So the district court said that this was not proper because the 11th Amendment said it was a constitutional bar. Very interesting issue, and it's a very complicated one. So let's read on. The panel, this court, holds that accepting the allegation in the amended complaint as true, the complaint did not run afoul of the sovereign immunity doctrine because the Koala sought only a return of eligibility to apply for funding, not an order directing the state to fund it. Okay. Moreover, the panel noted that because compulsory activity fees collected by the university are remitted to the Association State Student Government for reallocation, the suit's outcome would not increase or decrease the overall financial burden on the state. Yeah, you're just splitting the same money different ways. It would affect only what student organizations could apply for student activity fees and potentially how total student activity fees were distributed. In vacating the district court's dismissal of the freedom of press clause claim, the panel held that where a complaint alleges that the state singled out the press by withholding a subsidy in response to disfavored speech, the complaint alleges a viable Free Press Clause cause of action. The panel held the Second Amendment complaint's Free Press Clause claim was sufficient to survive defendant's motion to dismiss because it alleged that the Media Act was passed for the express purpose of silencing a newspaper, and defendants singled out the Koala for a disparate financial burden. The panel vacated the district court's dismissal of the Koala freedom of speech claim. So, vacated the dismissal, that's a double negative. We dismissed it, and now we're undismissing it. So that's what that's talking about. The panel vacated the district court's dismissal of the Koala freedom of speech claim, which alleged defendants violated the First Amendment right to free speech by creating a limited public forum consisting of the Students' Activity Fund and then closing a portion of the forum for the purpose of denying Koala access to it. The district court determined that the media funds category of the Student Activity Fund was a limited public forum that the university was free to close. Okay, that kind of makes sense. Student activity fee funds don't have to fund anything in particular. They don't have to fund media in particular. So it's a reasonable position to say that the university, by creation of funding media, is creating a limited public forum. So once you have the forum, there are rules, but the idea that you can shut down the forum completely seems a reasonable proposition on its face. Let's continue.
Now, okay, so if I understand correctly, though, they haven't adjudicated this on the merits necessarily. Sorry, let me rephrase. So this is on a motion to dismiss standard. Is that it? Like there was a motion to dismiss the claim, and then they're saying no, there's enough to proceed through discovery so that Koala can have a chance to get evidence that the response was based on their speech and not based off of budgetary concerns or something.
Yeah, exactly so. So the district court was on a motion to dismiss standard for failure to state a claim. Failure to state a claim because the district court said that even given the facts that you present, you're not presenting a legal argument. So there's nowhere to go. And the Court of Appeals is saying, well, no, that's not right. They do have somewhere to go. If their facts are true, then they have a legal basis given what they're asking for. So yes, we're on a motion to dismiss standard. So the actual issue of whether they were discriminated against, the actual issue of lots of things hasn't been decided. Just taking the facts as true for the purposes of the argument, assuming arguendo, as the lawyers like to say. Assuming arguendo, then they should have a viable claim. So let's go back to trial and figure out if they actually do or not. Make sense? Okay.
Yes, and assuming arguendo is my porn name, I've decided.
Okay, good.
It sounds so good. We need to use that phrase more.
Innuendo. That's horrible. Anyways, the panel that held the Student Activity Fund was a relevant forum for purposes of assessing the permissibility of defendant's action, and the district court analyzed the sufficiency of the Koala complaint using an incorrect framework. The panel remanded for consideration of the Koala's free speech claim in light of the panel's forum definition. The panel held the Second Amendment complaint sufficiently alleges a claim for First Amendment retaliation. The panel was unpersuaded by defendant's argument that the government's motive is irrelevant when it enacts a content-neutral rule of general applicability. So that's an interesting idea because we're doing something that's content-neutral. So the first thing that comes to mind is intermediate scrutiny standard rather than strict scrutiny standard. Because I'm thinking time, place, manner kind of restrictions. So this would, I would think, arguably be a manner restriction, basically saying we're not opening this forum. And so it says, well, motive is irrelevant. And the court is saying that's wrong because you have to have a higher rationale, I think. Let's see what the court actually is saying. First, the panel determined the Media Act discriminated based on the identity of the speaker because rather than applying to all registered student organizations, the act only applied to media organizations and singled them out for disfavored access to student activity fee funding. I'm not sure I agree with that conclusion. You don't have to defund all student organizations to be neutral in this sense. The issue is the forum, and the forum is the student media. So if you're defunding all the media equally, you don't have to defund all student organizations equally. That doesn't make sense. The ultimate Frisbee team isn't really making much of a First Amendment position other than ultimate frisbee kicks ass, but that's not really what we're talking about. Moreover, the Koala alleged that one of the other student organizations continued to receive funding for its print media. Well, that would be a big problem. That would show disparate treatment. Second, the panel held that it was bound by a prior decision, which held and emphasized that the motive was a necessary element of a retaliation claim, and which provides a framework for analyzing such a claim. Right. Applying that framework, the panel held that the Koala's article was clearly protected speech, the Media Act chilled the Koala speech, and the Koala adequately alleged a nexus, which means a tie, between its speech and the alleged retaliatory conduct. Concurring in the result in all but part 2 of the opinion, Judge Fisher would hold that a complaint, irrespective of motive, adequately alleges a claim under a free speech clause on the theory that the defendant singled out for disparate treatment. Okay, fair enough. So 2 judges say you have to show motive, and they're alleging motive, so go back and see if you can actually prove it at trial. The 3rd judge says, no, motive doesn't matter at all because the First Amendment analysis is enough. We don't need to do the retaliation treatment. It's just not something we need to deal with, because they're censoring all speech. So, the motive is relevant. So it's actually, in my view, a harsher position, but I do agree with the court what they're saying. Now, I want to see if we can actually find the article, see if the court quotes it, because I think we should read together what the Koala had to say and, all the butt hurt that resulted from it, don't you?
I'm getting flashbacks to undergrad right now.
This is
I
very...
had friends who were in student government, and it is so plausible that the student union was like, oh, these, insert denigrating name for someone who disagrees with you on the political spectrum. They're publishing crap. Let's just cut off their funding. Like, I can't believe that they get funding. It's so unfair that they get funding. Let's just cut it off. And there's probably emails to this effect.
Oh, I'm
because
sure there is.
These are like
students,
young 20-something students that don't realize that can be subpoenaed in a trial.
It should be an interesting case, yeah. I do like this fact here that the issue is over $452. This is the lowest funded newspaper I've ever heard of. When I was in student government back in the day, our student newspapers were funded to the tunes of tens of thousands of dollars. So, yeah, $452 is nothing. But hey, it's a constitutional issue, right? Are they actually going to quote the article? That'd be great. I don't think they do. That's very sad. Let's see if they attached it at the end. Blah, 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 blah. No, they didn't.
We have it in chat. I'm going to link it to you.
Oh, we have to read it together. Oh, I've got it. We've got this. We got to read it. Thank you.
Okay. Just note, if we read it, this is for evidentiary purposes and not because I agree or disagree with it.
Tactical agrees with it in every way.
I'm gonna have flashbacks to undergrad.
Hey.
The
Koala.
If I have to have a beer after this, it's your fault.
Hey. Well, as you can see from the Koala's logo here, it is a koala holding up a jug that says XXX on it. So the Koala is way ahead of you when it comes to the alcohol issue. Yeah. The Koala, the worst in collegiate journalism since 1982. I love these guys already. University of California, San Diego unveils new dangerous space on campus. Danger, unsafe space. I love these guys. This is the best article ever. Too long have trigger warnings plagued the airwaves. Too long has the no blacks rule been removed from our campus. Too long have students not been free to offend their hypersensitive peers. Spam Mubushi, only $1, and holy shit, they're up to Starbucks have been replaced by long chance of words I am not going to repeat on air. Next week, that will all change. Administrator at the University of California, San Diego are all creating a new state-of-the-art dangerous space for students who just don't feel like their needs have been met on campus. In the past few weeks, the lack of dangerous space at the university has become increasingly apparent. Students have been lashing out with puppy parades, nonviolent protests, and other equally safe gimmicks. Safe spaces at the university are commonplace and threaten individuals who do not feel like being safe. I love it. The logical next step has been taken by the university in creating a place to fairly support all students, continuing the theme of inclusion and equality. The satire drips off the page. It drips in thick molasses-like viscosity. Located at the center of the Liberty Walk, the new dangerous space is an ideal space for students to do whatever the hell they want. Senior Frank Yu gave the Koala the following statement. The need of dangerous space students has been overlooked for generations, but the university is finally recognizing what it means to most 19-year-old Asian nerds fucking a dead body with a picture of my wafer taped on the face.
Oh my god, that sounds like a card from Cards Against Humanity.
Wow, that's great. FU, nice touch. FU is not alone. Not only will the new data space allow people of all ethnicities and sizes, even unnaturally large sizes, if it will allow for knives, guns, opinions that might be different than yours, drug paraphernalia, sharp writing instruments, and explicit pornography.
Okay, this is really good writing.
The new
I thought it was going to be so much worse, but this is really good.
This is good. The new dangerous space is guaranteed to get students excited for a good time and will probably end like all good things do with body mutilation and feelings of remorse. Yes. Well, other than them saying the N-word 5 times for comedic effect, I thought it was a very nicely written article. So, yeah, I think it's great. Fun.
Besides the use of the N-word, and the thing is that like within the so obviously satire context, I'm kind of willing to forgive the N-word a little bit just because they've obviously branded themselves with a very particular style. They are not presenting themselves as legitimate journalistic. Or I shouldn't say that because satire is legitimate journalistic stuff, but you know, what was their slogan again? It was
the worst in collegiate journalism since 1982.
Yeah, so they're not taking themselves very seriously, and you don't go to them to have, you know, a thoughtful, nuanced article about whether safe spaces have a positive or negative effect on the populace. They're just talking about like, instead of safe spaces, let's talk about dangerous spaces with knives and opinions that differ from your own.
And they have regular staff meetings. I love it. The meetings at Home Plate, which is a bar near campus, Fridays at 4:20 p.m. Ha ha ha. Come talk shit and drink beer with your local alcoholic marsupials. Excellent. These guys are great. I'm gonna give them $5. I'm donating to them.
Yeah, I'm down for these guys continuing to exist.
Look at this latest issue that they have here in the graphic. Celebrating 35 years of drug and alcoholic abuse, the Koala Best Of issue. In this issue, incorrect math, free Chipotle, bestiality, pedophiles, big nugs, bananas, Helen Keller, and John Igris. These guys are my heroes. I believe in everything they stand for. We're now going to load this PDF and see what it has to say.
And I think satire and comedy have an important role in terms of getting people to think about their lives. So I used to joke that comedians were the original sociologists because they basically take a look at trends in society and situations in society and sort of turn it on its head and look at it from unexpected angles.
Mm-hmm.
And so like you can get a lot of insight into a society through comedy, and I believe that it's a legitimate form of analysis. Which is my this is my really academic way of saying like these guys are smart. That's what I'm saying.
This graphic for their best of issue is pretty entertaining.
I see lesbians. I'm okay with this.
We got the hot tub. I guess they're doing patent law analysis. This is special. Okay. Well, RIP fun. They got Tombstone. Campus Crusade. Free molestings. Ouch. That's harsh. Oh, man. I don't know about their university, but Campus Crusade at my university was Protestant, and it's depicted with Catholics here, so that seems a little odd, but okay. Anyways, that is all we need to know about the Koala. They're great, and student media didn't like them and defunded them because they can't take a joke. And someone in chat said they thought it was because of the N-word. I personally am not so sure. I don't know. It wouldn't have made that much of a difference either way because it's the University of California, San Diego. I'm betting that they wouldn't have taken it well in regardless. So might as well go for broke.